What happened this week isn't just a footnote in a dusty law book. It's a critical development for anyone who believes in local control and limited government. The Supreme Court just dropped an opinion that blindsided nearly everybody involved in the Second Amendment debate. We are talking about Missouri, a state that tried to put up a bold, muscular fight against what they saw as federal overreach, trying to effectively veto federal gun regulations within their borders. They passed a law, the Second Amendment Preservation Act, that carried teeth. Well, the Supreme Court, in a shocking 8-1 decision, slammed the door shut on that idea, at least for now. Only Justice Thomas stood alone with Missouri. 8 justices, including the ones many thought were in our corner, said, "Hold your horses, state legislators. The Supremacy Clause still runs the show here." Microscopic, this isn't just about guns, though that's the flashpoint. This is about who gets to say what the law is in your town when the feds disagree. Is Washington the sole referee, or do states still hold meaningful power? What unfolded in Missouri reveals a massive constitutional battle brewing beneath the surface. We're going to break down exactly what they tried to do, why the court, even this conservative-leaning court, said no, and what this means for every Second Amendment sanctuary city and county across this nation. Let's look at the sheer mechanics of this ruling. It wasn't a final judgment on the Missouri statute's constitutionality, not entirely. This was an emergency order, a quick rejection delivered via the shadow docket. An 8-1 rejection of Missouri's emergency request to keep their law active while the lower courts wrestled with it. When you see justices widely considered textualists or staunch originalists, like Gorsuch and Alito, joining the majority to reject the state's immediate plea, that's not a subtle disagreement. That is a thunderclap telling every state legislature across the country, you cannot unilaterally halt federal law enforcement within your borders, period. Bannon been past this thing. They weren't asking the feds to stop enforcing things across state lines. They were saying, inside Missouri, these federal firearm regulations are null and void. That's a dangerous, slippery slope, and it's one the Supreme Court has traditionally drawn a very firm line under, thanks to the Supremacy Clause. Federal law, when constitutional, is the supreme law of the land. Missouri tried to play the anti-commandeering card, the idea that the federal government can't force state employees to do their bidding. We've seen that doctrine successfully used before. A state can say, "We aren't going to use our limited manpower to staff your federal program." That's the shield. But Missouri didn't just put the shield up. They grabbed a sword. They didn't just refuse to cooperate. They actively declared federal laws unconstitutional inside their borders and slapped a $50,000 personal fine on any state or local employee who dared to help the ATF or any other federal agency enforce those very laws. That is where they stepped over the line from non-cooperation to active nullification. While the analogy to immigration sanctuary policies might sound good, legally speaking, it falls apart. Sanctuary cities refuse to spend local resources on federal immigration enforcement. Missouri tried to decree that federal laws cease to exist inside Missouri and threatened officers trying to enforce them. Big difference. The court recognized this wasn't about local autonomy. It was an assault on the federal structure itself. The minute Missouri's Second Amendment Preservation Act became law, the practical effects were disastrous for everyday law enforcement trying to keep the worst elements off the street. Task forces between local police and the ATF, partnerships designed to target major traffickers and violent gang members, suddenly dissolved. Why? Because local chiefs were faced with an impossible choice: help catch a known felon and risk owing $50,000, or stand back. Most chose the latter to protect their officers' livelihoods. Then you have the intelligence blackout. Missouri's own State Fusion Center stopped feeding information to Washington. Shell casings recovered from a shooting in Kansas City, Missouri, might hold the key to cracking an unsolved homicide across the state line. But because of this state mandate, that evidence sat locked in a closet. Leads died on a local shelf. that actively impedes justice for victims. And what about the concept of who gets to be a law-abiding citizen? Missouri's law was vague, leaving it up to local interpretation to define that term. Prohibited possessors, the felons and domestic abusers who absolutely should not have firearms, now knew that cooperation between state and federal agencies had been intentionally choked off. The most sickening part involved the case of a fallen Missouri officer. When an officer is murdered in the line of duty, the immediate weapon trace and tracing of the shooter's background is standard procedure. But even there, hesitation set in. State investigators stalled, worried that providing standard support to federal tracing agencies would trigger that crippling $50,000 fine. A state law designed to protect rights ended up delaying justice because political grandstanding interfered with basic police work. So, what does this 8-to-1 rejection signal for the hundreds of counties and the dozen or so states that have their own sanctuary declarations? It signals that the Supreme Court is not ready to endorse a wholesale declaration of constitutional nullification by state legislatures.
The court is saying clearly that while states can refuse to enact federal programs, they cannot declare federal laws, which have survived judicial review under the Supremacy Clause, to be void within their territory. That's Congress's job to pass laws, and the Supreme Court's job to interpret their constitutionality, not the Missouri legislature's job. This decision immediately impacts the political theater playing out in places like Alaska, Idaho, and Kansas, which have been watching Missouri closely. They can no longer copy the Missouri playbook of threatening fines and outright nullification without expecting the same swift judicial rebuke. They might try to water down their language, moving back to simple non-cooperation, but the court just showed them the absolute limits of that maneuvering. And here is the deeper issue for those who champion states' rights. If Washington knows that state and local agencies will simply stop assisting, what is the logical next step for the federal agencies? They have to ramp up their own efforts. The ATF and the FBI do not have the manpower to patrol every street in America solo. They rely on local partnership. When you intentionally break that partnership, you force the federal government's hand. They will be forced to dedicate more scarce federal agents, more federal dollars, and bring more cases into the federal system, which is precisely what many of these states claim they want to avoid. It's a self-defeating prophecy. By trying to assert total control, they've actually guaranteed more direct federal involvement on their soil, not less. This was a massive win for federal authority. The message sent through the shadow docket was loud and clear. You can push back, but you cannot declare supremacy when the highest court in the land has already spoken. For gun owners, this is a tough pill to swallow because it removes a key political pressure valve. For states' rights advocates, it means the line in the sand is drawn much closer to the federal government's side than they hoped. What do you think? Does this decision empower Washington over the states, or was Missouri simply trying to do something the Constitution doesn't allow? Have you seen this kind of tension between local enforcement and federal mandates in your neck of the woods? Drop a comment below if this hits home, because we need to keep shining a light on these maneuvers.